Today on Go Ahead Ask, today more than ever, there are reasons, so many reasons, why you might want or need to negotiate, buy, hold, exchange, or even sell real estate in a confidential and private manner. The title holding trust, or often referred to as a land trust, can accomplish that objective. But how do you actually use the title holding trust or land trust? Let's unravel that mystery today on Go Ahead Ask.
Building wealth in real estate? Let the Exeter Group take the mystery out of how it's done on Go Ahead Ask.
Welcome to the Go Ahead Ask podcast by the Exeter Group, where we unravel the mystery of investment real estate to provide investors with better quality information so that they can make better informed investment decisions. I'm your host, Bill Exeter, Chief Executive Officer of the Exeter Group today. The Exeter Group includes two primary operations. The first is Exeter 1031 Exchange Services, which serves as a qualified intermediary. We administer all types of 1031 exchanges. We cover all 50 states, and we're one of the few that will actually handle foreign property 1031 exchange transactions. It also includes Exeter Trust Company, which serves as custodian for self-directed IRAs and self-directed individual 401k plans, serves as escrow agent for specialized holding escrows, serves as trustee for title holding trust or land trust, which is the topic for today, and we also serve as custodian for general custody services and accounts. On Go Ahead Ask, as always, we encourage questions, we encourage topics, or even if you would like to appear on Go Ahead Ask, reach out to us. You can email us at ask@exeterco.com or call us at area code 619-239-3091. If you love Go Ahead Ask, please like it, subscribe to it, share it, and comment on it. We will comment and on any of the comments that you leave there, and happy to answer any questions you might have. Today, our podcast is entitled Unraveling the Mystery of Using Title Holding Trusts and Land Trusts. And at first, let's talk about that topic. A lot of people call it a land trust in about 49 states. In California specifically, it's been mostly referred to as a title holding trust, but it's really one and the same. And we're going to really unravel the mystery beyond what we talked about in episode 12 of Go Ahead Ask podcast. Back then, we discussed the history, the structure, the parties involved, the benefits, the tax issues, financing issues involved with using a title holding trust or land trust. And we also discussed what a title holding trust or land trust will not do, which is probably just as important as what it will do. Today, we're going to unravel that mystery further by diving into exactly how would you use, from a mechanical perspective, the title holding trust or land trust. So with that, let's go ahead and dive into unraveling the mystery of using title holding trust or land trusts. We've had a lot of listeners, especially after our episode 12, ask questions about title holding trusts or land trusts, and a lot of them focused on exactly how do you use it. Episode 12 was kind of a higher level. What are they? What are the benefits? What are the not so much benefits and things like that? This is going to go more into how do you actually use one and put it into practice. So with all of those questions, we decided we needed to kind of drill down on what a title holding trust is in terms of the mechanical steps and how you might actually implement the usage of a title holding trust or land trust. So first, we should probably talk about setting up a title holding trust. When do you set up a title holding trust? How do you set up a title holding trust? As we mentioned in episode 12, you've got a trust agreement. It's not recorded, and that's really what creates this trust. But the question is, when do you do that? Now, keep in mind, of course, the title holding trust or land trust has many benefits. In fact, we've got an article on our website entitled, the 24 benefits of a title holding trust. But the question is, when do you want to implement those benefits? So some folks want to not worry about it until they're ready to close on the purchase of real estate. Others do it after the close if their primary benefit is not confidentiality and privacy. And others are very, very concerned about confidentiality and privacy, so they want to start at the very beginning. So when do you set up the trust? And that's the first issue you need to look at. So you could certainly set up a title holding trust or land trust well in advance. And that way it exists. It's what we refer to as a dry trust. You've got the trust agreement in place. It exists. It's ready to go, but there's nothing in it. We're not holding title to any property yet. So you could certainly do that. And for those who want to, you can set it up in advance and then use the title holding trust for confidentiality and privacy as you go through the offering process, the negotiating process, and we'll talk more about that later. Others are not as concerned about the confidentiality of privacy up front, but they are once they close escrow or close on the acquisition of the property. So in that case, you may, go through your negotiating process and go through an offer, go through go under a purchase and sale agreement or sale or purchase contract. And then just before closing, you may want to establish the title holding trust or land trust. So those are kind of the mechanical steps you have to decide as to what you want to do. And we'll talk a little bit more about that in a minute. Then there's the funding of the title holding trust. And if you go back to episode 12, we talk about all the benefits of owning property, holding property inside of the title holding trust. And there's lots of reasons for doing that. If confidentiality and privacy of ownership is your primary objective, and that is for most people when they're using a title holding trust, then you really want to be able to set that up, have it in place prior to the close of your purchase, because as soon as you close on the purchase in your name, you're on public record. So most people are going to set that trust up and acquire title in that trust prior to the close of the transaction. If your objectives for using the title holding trust are other than confidentiality and privacy, we'll talk about a few of those, but most of those are discussed in episode 12. Those benefits can be obtained by putting the property into the title holding trust later, after the close, could be years later. But if your confidentiality and privacy issues are of paramount concern, then you need to have the trust set up before closing. So with that, let's kind of dive into more of the mechanical steps. So one of the areas that the title holding trust or land trust can provide a lot of benefits in is the negotiating process and the acquisition process. There may be situations where you want to or you need to negotiate, make offers, go under contract in a different name. You don't want people to know that you're the one that's acquiring or trying to acquire the property. So in that case, you'll want to set up your title holding trust or land trust well in advance so that it's ready to go and you're prepared. And then as you're negotiating, making offers, etc., you can do it under the name of the land trust. So in our case, if we are serving as trustee of the title holding trust on your behalf, you would give us guidance on what to do, and whether we are making offers or negotiating or communicating to the seller of the property, whether that's through email or if it's a physical letter, whether it's an option or letter of intent or anything like that, we would do it under the name of Exeter Trust Company as trustee of trust number 1, 2, 3, 4, 5. So all of that can be done. So let's get some specific examples as to why that might be necessary. First of all, it's usually some type of a competitive issue or competitive advantage. You may be a landlord, and maybe you're a large landlord and the seller wants to sell to a small independent property owner. Maybe you're a builder or developer, and if the seller knew that you were going to buy the property and develop it, take down the property and completely redo something, they may not want to sell it. There's all sorts of little issues like that. Some are very emotional, some are competitive, some are to avoid an increase in price. For example, we'll talk about this in a minute, but Walt Disney, when he entered Florida, if people knew Walt Disney was buying property, buying real estate in Florida, the prices would have skyrocketed. So he negotiated and acquired and assembled all the property he needed through Florida land trusts. So perfect example as to why that might be needed. Some people want to sell the property just to someone else who's going to live there as an owner, and they don't want to sell it to a landlord who's going to rent the property out. So you may need to negotiate to acquire that property through a title holding trust. So the first level of usage would be negotiating. For all sorts of reasons, some of which we just discussed, you may want to approach a seller of a specific property and on a confidential basis make offers, negotiate for the purchase of that real estate. And you could do all of that under the name of Exeter Trust Company as trustee of trust number 12345. So it keeps your name off of the negotiations, off of the offering process, and things like that. Whether you use just email, if you use a letter of intent, or if you go straight to a purchase and sale agreement, the person making the offer or person negotiating or person that's going to be the buyer in the purchase and sale agreement would be Exeter Trust Company as trustee of trust number 12345. So again, it keeps your name off of that record, if you will. It keeps you out of the limelight. So there's many reasons why you may not want to have your name out there when you're negotiating, going under contract and trying to acquire property. Same as making offers. So if you go straight to a purchase and sale agreement, when you draft the purchase and sale agreement, the purchase and sale agreement will be drafted with Exeter Trust Company as trustee of trust number 12345, and that would be listed as the buyer. And then Exeter Trust Company as trustee would execute all of the purchase and sale agreements, any amendments, addendums, and as you're going through the closing process, Exeter Trust Company as trustee would execute all of the necessary documents up to and including the closing, and then acquire and take title to that property as trustee of the trust. So really all through that process, you're behind the scenes, you're kind of driving the car, so to speak, but you're telling us as the trustee of the trust exactly what you want to do, what you want to say, what you want to offer, and then the terms that you're willing to accept, and then you authorize us to sign the purchase and sale agreement, all of which is done under our name as trustee of the trust and not under your name as an individual or as some other entity. If you're going through the closing process with either an escrow company, a title insurance company, or a closing attorney, the same thing is going to happen. All of the closing documents, the settlement statement, excuse me, the HUD-1, anything like that will also show Exeter Trust Company as trustee of trust number 12345 as the buyer. Everything that comes out of the closing will be in the trust company's name as trustee of the trust. So nothing will reflect your particular information on the documents. And most importantly, all of the recorded documents would also be deeded. For example, the deed, the warranty deed, etc., would be deeded into the name of Exeter Trust Company as trustee of trust number 12345. And that's part of the important part, is to make sure that your name doesn't show up on anything within that process, especially any documents that might be recorded. If there's a documentary transfer tax stamp form, if there's a preliminary change of ownership report form, anything like that, they would also reflect Exeter Trust Company as the buyer of that particular real estate. It's important that everything be under the trustee's name in order to ensure that your ownership is confidential and private in nature. Any correspondence, again, would be under our directive, whether it's under our email or a letter that we draft, but it would come from you. You'd be behind the scenes, again, driving that car where you're instructing us on what to say, how to negotiate, what to offer, etc. So that really all falls under kind of the broad area of negotiations and acquiring real estate, any kind of the acquisition process. Once you get past that, now we go into the holding process. Now we're holding title to this real estate. Why do some people want that and why do others not want that? So again, probably the biggest reason for using a title holding trust or land trust would be the privacy or the confidentiality of ownership. Now, why is that important? Well, everybody has different reasons for needing or wanting the confidentiality and privacy of ownership. In today's world, there is all sorts of stuff, if you will, going on out there. There's all sorts of people trying to invade our privacy, whether it be a concern over cybersecurity, theft of your private personal information. Maybe you just don't want your name in the public record. Maybe you're in the entertainment world. Maybe you're in the law enforcement or judicial world, and you just want your name off of the recorded public record. Those are just examples of why you might want that. So let's kind of go through a few of those examples. So one of which is anybody who owns rental property, whether it be a single family property, if it's multi-family property, even if you get into commercial office rentals, retail office or retail site rentals, anything like that, the tenants can drive a landlord crazy. There's always that one or two tenants that just drive you bananas. So folks like to say, look, I'm going to hire a property management firm to handle the property management. But there's still tenants who bypass the property manager and track the owner down so that they can badger them if they have a concern or whatever it might be. So a lot of folks will set up the ownership structure so that it's owned in a title holding trust, so that the only entity that shows up on recorded title would be Exeter Trust Company as trustee of trust number 12345. The tenant can't do a property search or other record search and track down the real owner of the property because it's always going to come back to us. So whether that be, what I just described, which is you're trying to avoid the tenant from contacting you directly and bypassing your property managements, you're trying to avoid or prevent the tenant from contacting you directly to renew the lease or anything like that, you can use the title holding trust to put up that wall, if you will, so the tenant can't track the real owner down. Now, going back to my other comment about law enforcement and judicial folks, it's very common, obviously, that they may arrest somebody, put them in jail for an extended period of time, and the last thing they want when, especially the recurring and violent offenders are released, to be able to just do a public record search and find out where the law enforcement officer or the judge and what have you live. So the title holding trust is often used for something like that, to keep their name off the recorded title so they can't figure out where they live just by doing a record search. You have the same type of issues in the entertainment world. If you're working in the entertainment world, you're an actor, an actress, director, etc. There's a lot of fans out there, and some of which go a little crazy sometimes. So by using the title holding trust, you could take your name off of the public record and they can't track you down as to where you live. I mean, there's obviously ways to try to follow you home, but it makes it a lot more difficult. You can't just log in and do a title search. Then unfortunately, we have stalking victims that have been abused, and it may be spousal abuse or other type of stalking scenarios. And they are forced to relocate. They're forced to go into hiding. They don't want their stalker to track them down. So one of the ways is the use of a title holding trust to keep their records private and confidential, so it's a lot harder for the stalker to track them down, especially if they have ended up in prison once they get out of the prison. We're going to take a quick break for a message from our sponsor. This episode is sponsored by our sister company, Exeter Trust Company. Did you know that all individual retirement accounts are self-directed IRAs? It's because you choose where to put them. You choose whether to put your self-directed IRA at a bank or at a securities or brokerage firm or a life insurance company. So that makes it self-directed. But did you also know that all IRA custodians are not created equal? Most IRA custodians, like the banks, the securities firms, and the life insurance companies, limit you to publicly traded investments such as stocks and bonds and mutual funds. But some IRA custodians, like Exeter Trust Company, allow investors to invest their IRA funds in other alternative assets such as real estate. Investors can acquire real estate, mortgages, deeds of trust, or tax lien certificates inside the IRA as an investment inside the IRA. To learn more, call Exeter Trust Company at area code 307-222-8750 or visit them on the internet at exetertrustcompany.net. There's also concerns for liability and litigation. So we kind of briefly talk about all of those in episode 12, but let's drill down a little deeper. With liability and litigation, if something happens, let's say on the property, they're probably going to just sue us as trustee of the trust, and there's not a whole lot the title holding trust can do at that point. However, if something else happens, maybe it's a car accident, any other type of episode that may create a potential liable situation for you, and that person hires an attorney, they're probably going to do some type of a search to see if you own assets, if you own enough wealth to go after. Are you worth going after? So one of the objectives with the privacy and confidentiality is to keep your name off of the recorded title so that you don't show up in those searches. And hopefully the attorney they hire say, look, this person's not worth going after. They don't own real estate. They don't have any assets that I can find. It's just not worth going after them. So that's part of this overall holding process. Those are just some of the examples as to why people might use the title holding trust, and specifically on a case-by-case basis, what might apply to you. The next category is kind of probate and estate planning. And again, we mentioned that briefly in episode 12, but let's kind of use a real-life scenario. Let's assume you're in California. You own real estate here in California. You live in California. You're a resident, officially a resident of California. You set up a living trust in California. Your primary residence, and maybe any rental property you have and other assets you own in California is held in your name as trustee of your living trust. So those assets are already taken care of in terms of being inside of a trust for probate and estate planning purposes. Upon your death, that trust will bypass probate. Your heirs, presumably your kids or grandkids or whomever you've left the property to, get immediate control of that trust. They become the beneficiary of the trust, and they get immediate access to the assets in those trusts. So that bypasses probate, because probate could be 6 months. I've seen some probates that are really complicated, really nasty, go 10 years, but a lot of probates could be 6 months minimum to maybe a year or 2 years, where the living trust will bypass probate. The living trust does not provide you with confidentiality or privacy of ownership because it's in your name as trustee of your trust, but it does bypass probate. If you wanted the privacy and confidentiality as well, we could set up a title holding trust or land trust to acquire and hold title to the real estate, and the title holding trust would name your existing living trust as the beneficiary. So the existing living trust would own, if you will, the title holding trust. It folds very nicely right into your existing trust and estate plan. Then you would have the confidentiality and privacy of ownership benefits, but it folds right into your existing living trust for the estate planning and probate avoidance. Now, what if you buy real estate outside of the state of California? In that case, you're buying real estate, let's say in Arizona or maybe Nevada or maybe Wyoming, where Exeter Trust is located. In that case, you're buying real estate outside of the state where you live as a resident. So let's just, because Exeter Trust is located in Wyoming, let's use Wyoming as an example. So you buy real estate in Wyoming, and at that point, you just buy it and you hold it in your individual name, or you hold it in your living trust that you have set up here in California. Because that real estate is in a different state, most state laws require a foreign property owner, as a California owner, to still go through probate. So even though you've acquired that property in your living trust, you don't live in Wyoming, the trust is not domiciled in Wyoming, so you still have to go through Wyoming probate in most cases to go through that upon your death. Now, if you had acquired that real estate in Wyoming through a title holding trust or a land trust, and then that trust would again name your living trust as the beneficiary, you would avoid what they call ancillary probate in Wyoming, and you would also avoid probate in California. So you avoid both probates, and all of the property gets passed immediately to the heirs that you mention or list as beneficiary in your trust. So there's a lot of ways you could take advantage of the title holding trust, not only for privacy and confidentiality of ownership, but also to avoid probate in certain states, to avoid ancillary probate when you buy property in a state different than where you live, etc. So there's a lot of estate planning and requirements there. There's a lot of benefits also in terms of gifting real estate. So for example, you own a property and you say, you know, I'm allowed to give up to $15,000 per year per person, and I want to start doing that. But in real estate, you'd have to value the property, determine what percentage of the property $15,000 equates to, which is a very small fractional interest in today's world. And then every year you'd have to record a deed or a warranty deed of some type or a quitclaim deed and transfer a very small fractional interest in that real estate to your kids or grandkids or whoever you're leaving the property to. That has recording fees. It may trigger a letter from the county assessor, county recorder asking what's going on, and things like that. The other way to address that is to put the property into a title holding trust. You'd still have to value the property and compute what percentage of the property equates to a $15,000 gift. But then all you do is assign a portion, a very small fractional portion of the beneficial interest to your kids or grandkids or whomever. There's nothing recorded, there's nothing on title, etc. It's all confidential. So there's a lot of benefits for conveying title, gifting property, and things along that line. So that's kind of some very specific examples of how you would use a title holding trust or land trust and kind of more of the mechanical steps of how you would use it. I think almost just as important is what does it not do? And we should drill down a little bit on that. So in episode 12, we did discuss a couple of those items. Probably the two areas where, unfortunately, there is the most abuse of title holding trust or land trust is either in trying to avoid reassessment of the property for property tax purposes or avoid the due on sale clause in loan documentation. So I guess the first category, let's take the due on sale clause. That kind of falls under what a lot of folks would technically call loan carve-outs, also known as bad boy provisions. If you do certain things, the loan becomes immediately due and payable, or you're under technical default of the terms of the loan, etc. So one of the areas people try to get creative in is say, well, if I could sell this property and allow the buyer to assume the existing loan or take title to the property subject to the existing loan, why not? And of course, the lender typically won't. A lot of loans are not assumable. And so if you were to call the lender and say, this is what we want to do, I'm going to sell the property to this buyer, and this buyer will begin to make payments to you. And the lender will say, this is not an assumable loan. You can't do that. So the investors try to avoid that and put the title into a title holding trust. And then when they're ready to sell the property to that buyer, they just assign the the beneficial interest in that title holding trust to the buyer so that nothing is recorded. And they'll tell you that that gets around the due on sale clause. And then I would say in 99% of the cases, that is not the case. Number one, if you read the loan documents, all the terms and conditions, especially the carve-outs or the bad boy provisions, in most cases it says a conveyance to a third party will result in an immediate due on sale of the loan. So it triggers the due on sale clause when you convey title to a third party. Those who argue in favor of using the title holding trust like this will say, yes, but this is just assigned inside the trust. There's nothing on recorded title. All that means, best case, is that it's unethical. Worst case, the lender finds out about it, says you have committed loan fraud. And if you do it a lot, they may want to go down the path of criminal loan fraud or criminal fraud. Because generally, if you call the lender and ask, hey, can I do this? If the lender's going to say no, it's wrong, and the loan documents don't allow for that, and then you go around and do it anyways through a title holding trust, the assignment of a beneficial interest has the same impact for all purposes as the recording of a grant deed or a warranty deed or a quitclaim deed. So the assignment of that document, the assignment of the trust or the beneficial interest, is conveyance of the underlying assets for legal and tax purposes. And most loan documents are worded in such a way that that would trigger the due on sale clause. So a lot of folks say, well, I do it all the time and I've never had a problem. Well, the issue is you've never gotten caught. That's the problem. So you have to be very careful. The title holding trust or land trust is not designed to avoid due on sale clauses. So unless the loan documents, loan agreement, loan promissory note, et cetera, provide or allow for the assignment of a beneficial interest in a land trust, it's probably going to trigger the due on sale clause. So don't just do that because people say they do it all the time. There are issues with that, and it's probably lender fraud. The same type of issue goes for property tax assessments. So people say, I don't want to sell this property and have the buyer have the property reassessed. where I get hit with a much higher property tax bill every year going forward. So they'll put the property into a title holding trust, and then when they sell the property to the buyer, they just assign the beneficial interest in the trust. Nothing's recorded, so the property tax never gets reassessed. Most counties, most of the documents, most of the codes and the regulations I've read consider that to be a conveyance of title. Assigning the beneficial interest in a title holding trust or land trust is considered conveyance of title, and generally you have to notify the local jurisdiction, whether it be a county assessor, recorder, or what have you, that you've conveyed title to a buyer and it is subject to reassessment. So the proponents of that strategy are really telling you, well, I do it all the time, but that means they just haven't got caught. It is a conveyance of title to a third-party buyer, and it will trigger a reassessment of the property for property tax purposes. And it probably is tax fraud if you're doing it on purpose. So be very, very careful with that scenario. So we've talked about how you can use the title holding trust to negotiate and acquire property in a confidential and private manner. We've talked about a lot of the reasons that you might do that, and you probably have a lot of your own personal reasons for doing that. I talked to someone yesterday who had said, I'm trying to buy my neighbor's property, but my neighbor hates me. He's going to sell his property no matter what, and I really would like to buy the property next door for my other family members, so he's doing that through a title holding trust. So the neighbor doesn't really know who's negotiating and offering and actually acquiring that property. So there are all sorts of reasons why you might need confidentiality through the negotiation acquisition process. And then for a lot of the reasons we talked about, there's all sorts of reasons you want to hold the real estate in a confidential and private manner. The one area I didn't mention, but I thought of just now that we should talk about quickly, is politics. There are a lot of folks that are in the political arena, whether they actually be politicians or if they are someone who's very publicly involved with supporting politicians or working on campaigns, they especially need that privacy and confidentiality of ownership because of all that's involved with that particular scenario. There's just a lot of let's just say politically correct, interesting people out there, and the last thing you want them to do is kind of like track you down when you've used something, when you're involved with something like entertainment, law enforcement, judicial, political, etc. So with that, we've talked a lot about the title holding trust and the specifics. Do you have any specific questions on your situation and how you might be able to implement that? Give us a call. I'll be happy to chat about that. Thank you for listening today for Go Ahead Ask podcast. We've had a lot of interesting programs over the last couple of weeks. The most recent one was the same type of approach, which was drilling down on self-directed IRAs. That was episode 23. So if you're interested in really getting into the step-by-step process on how to buy real estate inside of your self-directed IRA or self-directed individual 401k plan, check out our last episode, episode 23. We've got some great ones coming up. We're going to try to get the next one to be a topic of title insurance. And how does that affect you? What is title insurance, et cetera? It's amazing how many people really don't understand title insurance. So I thought, an episode drilling down on what is it, why do you need it, what do you use it for would be very, very beneficial. As always, if you like or love Go Ahead Ask, please like it, share it, subscribe to it, and comment on it. We will respond to your calls, your questions, et cetera. If you've got a topic you'd like to cover, a question you want us to answer, email us at ask@exeterco.com. Give us a call at 619-239-3091. Again, thank you so much for listening to Go Ahead Ask today. We'll see you next time.
Thank you for listening to Go Ahead Ask with the Exeter Group. Join us for our next episode when we further unravel the mysteries of real estate.